So the 10th Circuit Court of Appeals has affirmed your right to record police while also taking away qualified immunity from a police officer who invaded that right. Let's take a look at the case of Abade Irizarry versus Yehia. This is a 4-publication precedential opinion out of the United States Court of Appeals for the 10th Circuit. The 10th Circuit is Wyoming, Utah, Colorado, Kansas, Oklahoma, and New Mexico. And this case was decided on July 11th. Mr. Irizarry is a YouTube journalist and blogger who regularly publishes stories about police brutality and conduct or misconduct. On May 26, 2019, he and 3 other YouTube journalists/bloggers were filming a DUI traffic stop with their cell phones and cameras, quote, for later broadcast, live streaming, premieres, and archiving for their respective social media channels. Officers on the scene contacted Officer Yehia to report that 4 males were filming the traffic stop. Officer Yehia drove to the scene in full regalia in a marked cruiser with every single light turned on. He exited his vehicle and intentionally positioned himself directly in front of Mr. Irizarry to make sure he intentionally obstructed the camera view of the DUI roadside sobriety test. Mr. Irizarry and another journalist, Eric Brandt, voiced their disapproval of the intentional obstruction and began to loudly criticize Officer Yehia. Officer Yehia shined an extremely bright flashlight in Mr. Irizarry's and Mr. Brandt's cameras, saturating the camera sensors. Officer Yehia continued harassing Mr. Irizarry and Mr. Brandt until another officer told him to stop. Officer Yehia got back into his cruiser, drove right at Mr. Irizarry and Mr. Brandt, and then sped away. He made a U-turn, gunned his cruiser directly at Mr. Brandt, swerved around him, stopped, then repeatedly began to blast his air horn at the 2 men. Eventually, Officer Yehia was instructed to leave the scene due to his disruptive and uncontrolled behavior. Mr. Irizarry sued Officer Yehia under 42 U.S.C. Section 1983, claiming that the officer violated his First Amendment rights. He alleged that Officer Yehia's actions amounted to a blatant prior restraint and deprived him of his rights to freedom of the press. The complaint also stated that Officer Yehia sought to punish Mr. Irizarry for exercising his First Amendment rights. Officer Yehia moved to dismiss the case under Federal Rule of Civil Procedure 12b-6, failure to state a claim, asserting a qualified immunity defense. The district court granted the motion. It concluded that the complaint alleged a First Amendment constitutional violation based on prior restraint and retaliation. Although the 10th Circuit had not previously recognized a First Amendment right to record police officers performing their official duties in public, the court, relying on out-of-circuit decisions, or non-precedential decisions, or non-binding decisions that are not precedential in the 10th Circuit, they held that the First Amendment guarantees such a right subject to reasonable time, place, and manner restrictions. But the district court nonetheless held that Officer Yehia was entitled to qualified immunity because Mr. Irizarry had not shown a violation of clearly established law. And this is one of the problems with qualified immunity, is that some courts see this requirement of clearly established law as meaning a very specific set of facts. So if an officer commits a misconduct on the left side of the road or the left side of the driveway, that might be different than than a situation where he did it on the right side of the driveway. So some of these things get super specific, as you'll see here. Mr. Irizarry failed to direct the court to a case which demonstrates that Officer Yehia was on notice that standing in front of and shining a flashlight into Mr. Irizarry's camera violated Mr. Irizarry's First Amendment rights. The court therefore dismissed the suit against Officer Yehia with prejudice. So essentially the 10th Circuit is saying that there's no clearly established law that says it's okay to turn on your flashlight and shine it in somebody's eyes and their camera and try to disrupt their ability to film. Now, there's a philosophical exercise that we can do. We often talk about how you have the right to swing your fists until you put me in reasonably foreseeable or reasonable anticipation that you're going to actually make a harmful or offensive contact. And it has been ruled that rolling coal and blowing black smoke on someone is a physical intrusion that can amount to assault or battery. It's been ruled that sound waves can be high enough when intended to cause harm that they can be considered an assault or battery, as opposed to just like a nuisance from loud music or something. So how is directing photons, an enormous number of photons, towards someone's camera or eyes, not also considered an assault at some threshold? We play the game of hyperbole. We use mental exercises to find the boundary conditions for things. So hyperbole, in this case, would mean, let's think of a case where it does clearly violate some kind of law or someone's human rights or civil rights. Let's think of a high-powered laser. Would it be okay to shine a high-powered laser into someone's eyes or into someone's camera? No, that would very clearly be some kind of assault or battery. We have people who are arrested all the time for that kind of behavior, especially including shining lasers into pilots' eyes in flight. So it's obviously something that is illegal, that is clearly established. So then, backing down the line, how bright of a light do you need to have? Probably to the point that it causes some kind of disruption or disorientation or some kind of damage. And I think that is clearly something that Officer Yehia was accused of doing here. Now, I should note that this is at the motion to dismiss stage. So we are going to assume that what Mr. Irizarry has alleged is true. He hasn't proven it yet, though. We're just going to assume it for the purposes of a motion to dismiss. If we can overcome the motion to dismiss, Mr. Irizarry will then have to prove it with actual facts and evidence, admitted in a court of law later on, potentially in a trial. Mr. Irizarry appealed. We review brand new a district court's ruling on a motion to dismiss a complaint because of qualified immunity. We accept all well-pled factual allegations in the complaint as true, as I've just said. We view them in the light most favorable to the opposing, non-moving party, so Mr. Irizarry. To survive a motion to dismiss, a complaint must contain sufficient facts accepted as true that those facts state a claim to relief, and that claim has to be plausible, not just possible, but plausible when looked at facially. We're not reading into it, we're just looking at what it says on its face. As to the qualified immunity standard, Section 1983 of Title 42 provides that a person acting under color of law who subjects or causes to be subjected any citizen of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured. Individual defendants named in a 1983 action may raise a defense of qualified immunity, which shields public officials from damages actions unless their conduct was unreasonable in light of clearly established law. When a defendant invokes qualified immunity, the plaintiff can overcome it by showing 1, the defendant's actions violated a constitutional or statutory right, and 2, that right was clearly established at the time of the defendant's complaint of conduct. To state a First Amendment retaliation claim, a plaintiff must allege facts showing that he was engaged in constitutionally protected activity, that the defendants caused the plaintiff to suffer an injury, that injury would chill a person of ordinary firmness from continuing to engage in that activity, that the defendant's adverse action was substantially motivated as a response to plaintiff's exercise of the constitutionally protected conduct, or any constitutionally protected conduct. Discussion. The complaint alleged a First Amendment retaliation claim under clearly established law, so Officer Yehia is not entitled to qualified immunity. We reverse. They explain. The pro se, unrepresented complaint did not use the word retaliation, but it alleged that Officer Yehia was motivated to punish Mr. Irizarry for exercising his rights. To the extent the complaint attempted to allege a prior restraint claim, Mr. Irizarry has abandoned that theory. Although Officer Yehia does not contest the district court's determination that he violated Mr. Irizarry's First Amendment rights, we analyze whether the complaint alleged a retaliation claim as a necessary predicate to our discussion of clearly established law. So they're going to try and establish whether he actually made a retaliation claim. So to make a retaliation claim under the Worrell case, you need 3 things. On constitutionally protected activity, they say Mr. Irizarry has alleged facts showing that he was exercising his First Amendment right to film police, that the alleged actions of Officer Yehia would chill a person of ordinary firmness, and that the complaint properly alleged that Officer Yehia was motivated by Mr. Irizarry's protected filming activity, so therefore it was a constitutional violation. Now, we're not really worried about whether it was a constitutional violation for our purposes today. I'm interested in how the court got to the qualified immunity analysis, which I think will be much more interesting. So we're going to skip ahead to the qualified immunity section. So on the clearly established prong, Mr. Irizarry has also shown that Officer Yehia violated his clearly established right to be free from retaliation for filming the police performing their public duties. A clearly established right is one that is sufficiently clear that every reasonable official would have understood that what he is doing violates that right. The law is clearly established when a Supreme Court or 10th Circuit precedent is on point, or the alleged right is clearly established from case law in other circuits. Thus, even without Supreme Court or 10th Circuit precedent, persuasive authority from other circuits may clearly establish the law in this circuit when that authority would have put a reasonable officer on notice that his or her conduct was unconstitutional. See Ullery versus Bradley from the 10th Circuit. Law was clearly established based on the consensus of persuasive authority from 6 other circuits. So you can use persuasive authority from other circuits outside the 10th Circuit to establish a clearly established right. That's better. That's movement in the direction of the civil rights of the citizens and narrowing qualified immunity. And that's what we want to see. We want to see a narrowing of qualified immunity. It is too protective right now, way too protective. To determine whether the law is clearly established, the relevant precedent is considered on point if it involves materially similar conduct or applies with obvious clarity to the conduct at issue. Thus, general statements of the law can clearly establish a right for qualified immunity purposes if they apply with obvious clarity to the specific conduct in question. So this is limiting it to conduct that isn't obvious, meaning your police officers can't simply sit back on ignorance and say, oh, well, it wasn't obvious to me. Instead, they have to use what I think we would call common sense or not so common sense, and not act like Officer Yehia is accused of in this case. When the public official's conduct is egregious, even a general precedent would apply with obvious clarity. So the more egregious the conduct, the easier it is to establish a clearly established law. To overcome qualified immunity here, Mr. Irizarry must show that when the incident occurred, it was clearly established that 1. He was exercising a First Amendment right to film police performing their duties in public, that 2. Officer Yehia's action would chill a person of ordinary firmness from continuing to film the traffic stop, and 3. Mr. Irizarry's protected activity motivated Officer Yehia's actions. In May 2019, when the incident occurred, Mr. Irizarry did have a clearly established right to film the traffic stop based on the persuasive weight of authority from 6 other circuits and our decision in the Western Watersheds case. Officer Yehia's obvious interference with that right, motivated by Mr. Irizarry's protected conduct, was a violation of clearly established law. On the protected activity prong, although neither the Supreme Court nor the 10th Circuit has recognized a First Amendment right to record police performing their duties in public, we hold that the right was clearly established here based on the persuasive authority from 6 other circuits, which places the constitutional question beyond debate. Our opinion in the Western Watersheds case also supports this conclusion. As we said in Ullery, in the absence of binding precedent specifically adjudicating the right at issue, the right may still be clearly established based on a consensus of cases of persuasive authority from other jurisdictions. And the weight of authority from other circuits may clearly establish the law when at least 6 other circuits have recognized the right at issue. In this case, our source of clearly established law comes largely from other circuits. As discussed in the part that we skipped, the 1st, 3rd, 5th, 7th, 9th, and 11th circuits have concluded in published opinions that the First Amendment protects a right to film police performing their duties in public 4 of those opinions, the Fordyce, Glick, Fields, and Turner opinions, involved facts materially similar to those here. The plaintiffs, like Mr. Irizarry, were attempting to film the police performing their official duties, but were dissuaded from doing so either because they were arrested, detained, or physically deterred. Alvarez involved a pre-enforcement challenge to a statute that made it a felony to film police officers in public. All 6 decisions held that there is a First Amendment right to film the police performing their duties in public, which clearly establishes the law in this circuit. Moreover, in the Western Watersheds case, we indicated without reservation that filming the police performing their duties in public is protected under the First Amendment. Quote, an individual who photographs animals or takes notes about habitat conditions is creating speech in the same manner as an individual who records a police encounter. Although this statement on its own may be insufficient to satisfy prong 2 of qualified immunity, it supports the conclusion that a reasonable officer would have known that there was a First Amendment right to film the police performing their duties in public. Finally, Mr. Irizarry's right to film the police falls squarely within the First Amendment's core purposes to protect free and robust discussion of public affairs, hold government officials accountable, and check abuse of power. We have no doubt that Mr. Irizarry had a clearly established First Amendment right to film the traffic stop in 2019. Now let's go back and survey those 6 or 7 cases that were referred above, because I think they'll make things really clear. In the Western Watersheds case, the plaintiffs challenged 2 Wyoming statutes that imposed heightened penalties above and beyond Wyoming's general trespass provision on any person who crosses private land to access adjacent or proximate land where he collects resource data. So I'm assuming this was about filming farms, factory farms. The statutes defined the phrase collects resource data to include gathering information about numerous activities on public lands, such as writing notes on habitat conditions, photographing wildlife, or taking water samples, so long as an individual also records the location from which the data was collected. Plaintiffs argued that this statute violates the First Amendment, relying on decisions from other circuits recognizing a First Amendment right to film the police in public. We held that the statutes regulated protected speech. We said that an individual who photographs animals or takes notes about habitat conditions is creating speech in the same manner as an individual who records a police encounter. The Fordyce decision, Mr. Fordyce was videotaping police officers working a public protest, and one officer attempted to physically dissuade him from doing so. He brought a civil rights claim against various officers for interfering with his First Amendment right to gather news. The district court granted summary judgment to the defendants, but the Ninth Circuit reversed, concluding there was a genuine issue of material fact regarding whether he was assaulted and battered by a Seattle police officer in an attempt to dissuade him from exercising his First Amendment right to film matters of public interest. Smith v. City of Cumming. City police prevented Mr. Smith and his wife from videotaping their actions. Glick v. Cunniff. Police arrested Mr. Glick for trying to film officers arresting a young man. He sued them. The court explained, the filming of government officials engaged in their duties in a public place, including police officers performing their responsibilities, fits comfortably within established First Amendment principles regarding news gathering and the public's right to receive information. ACLU of Illinois v. Alvarez. This was a pre-enforcement challenge. The court explained that the act of making an audio or audiovisual recording is necessarily included in the First Amendment's guarantee of free speech and free press rights as a corollary of the right to disseminate the resulting recording. And because the statute interferes with the gathering and dissemination of information about officials performing their duties in public, the eavesdropping statute burdens speech and press rights and is subject to heightened scrutiny. Fields versus City of Philadelphia. 2 incidents in which police interfered with the appellant's ability to record the police. In the first one, the appellant was trying to film an arrest during a protest when an officer abruptly pushed her and pinned her against a pillar for 1 to 3 minutes, which prevented her from observing or recording the arrest. In the second, the appellant took a photograph of the police breaking up a house party, and an officer ultimately arrested him, confiscated his phone, and detained him. The Third Circuit said there is a First Amendment right to record police activity in public subject to reasonable time, place, and manner restrictions. The court explained that the First Amendment protects actual photos, videos, and recordings, and for this protection to have meaning, the amendment must also protect the act of creating that material. Turner versus Lieutenant Driver. Mr. Turner videotaped a police station from a public sidewalk across the street. 2 officers approached him, asked for his ID, and detained him for investigation because they were concerned about who was walking around with a video camera. The officers eventually released Mr. Turner and returned his camera, which they had confiscated. The Fifth Circuit concluded that the First Amendment protects the right to record police in public, etc. Now, Officer Yehia's counter-arguments. Officer Yehia argues that the right to film police officers performing their duties in public cannot be clearly established unless a previous 10th Circuit case has already recognized the right. But we have repeatedly said that the weight of authority from other circuits can clearly establish that right. They had 6 or 7 other cases. Officer Yehia also argues that Frazier v. Evans shows that the right to film police officers while performing their duties in public was not clearly established as of May 2019. In Frazier, the plaintiff filmed police officers in 2014. There, the 10th Circuit held the officers were entitled to qualified immunity because when the incident occurred in 2014, the law was not clearly established. The 10th Circuit goes on, the legal landscape has changed since August 2014 when the Frazier incident occurred. Since then, the 3rd and the 5th Circuit have joined 4 other circuits in concluding that there is a First Amendment right to film police. Second, this represents a consensus between other circuits, and that is what overcomes the requirement for the weight of authority from other circuits. It was also clearly established that Officer Yehia caused injuries sufficient to chill a person of ordinary firmness from filming a traffic stop. I wasn't aware that that had to be clearly established, but a reasonable officer would have known that physically interfering with and intimidating an individual who was filming a DUI traffic stop can chill First Amendment activity. And on the obvious clarity test, in Worrell, we described the objective retaliation element as actions causing injury that would chill a person of ordinary firmness from continuing to engage in protected activity. Although this is a general statement of law, it can supply clearly established law here because it applies with obvious clarity to the specific conduct in question. Because filming police conduct in public is a clearly established First Amendment right, it would be obvious to a reasonable officer that blocking Mr. Irizarry's filming, shining a flashlight into the camera lens, and driving a police car at him in response would infringe First Amendment protected activity and chill its exercise. The 10th Circuit also concludes that the sibling circuit cases, some of which are at least as egregious as this case, also help establish these rights. And then there's the Van Dalen opinion, or Van Deelen opinion. There, a sheriff's deputy threatened to use lethal force against a plaintiff if he brought tax appeals, and the deputy physically bumped into the plaintiff during a meeting. Other county officials scowled and stared at the plaintiff. We held the defendants who made the alleged threats were not entitled to qualified immunity because, as of 2005, it was unremarkable that a reasonable government official should have clearly understood that physical and verbal intimidation intended to deter a citizen from engaging in protected First Amendment activity violates that citizen's constitutional rights. Officer Yehia's conduct was at least as serious as the defendant's conduct in Van Dalen, for 2 reasons. First, rather than merely discouraging Mr. Irizarry from engaging in protected activity, Officer Yehia physically interfered by standing in front of Mr. Irizarry and shining a flashlight into his camera. Second, Officer Yehia went beyond threatening violence against Mr. Irizarry. When he drove his police cruiser right at him and gunned the vehicle at his colleague, he could have caused serious injury or even death. Officer Yehia's conduct was so disruptive and uncontrolled that he was instructed to depart the scene. And as discussed above, the complaint adequately alleged that Officer Yehia's actions, like the defendant's conduct in Van Dalen, were substantially motivated by the protected activity. Van Dalen would give a reasonable officer further reason to understand that Officer Yehia's actions caused injuries sufficient to chill a person of ordinary firmness from continuing to film the traffic stop. On the motivation prong, the 10th Circuit says Mr. Irizarry has shown that a reasonable officer would have known that his conduct would chill a person of ordinary firmness, so it follows that a reasonable officer would also know that Officer Yehia committed a First Amendment retaliation violation when Officer Yehia acted the way he did in response, allegedly. So they conclude that there will be no qualified immunity for Officer Yehia under these facts, assuming that Mr. Irizarry can prove these facts by preponderance of the evidence. So whoever's case is more convincing wins, and that may be before a judge in a bench trial or a jury in a jury trial. But if he proves those facts, then under those facts, there will be no qualified immunity for Officer Yehia. That's great. This case means that we now have yet another circuit recognizing as clearly established precedent your First Amendment right to record police officers while they are performing their duties in public. There are reasonable time-place requirements, meaning you're going to need to stand back, you're going to need to not interfere with the investigation, you're going to want to be on public land or private land with permission. So there's some more to this. Don't take my summary as legal advice for you to go become a First Amendment YouTube auditor. There's some danger to that, and there's some risk of actual legal consequences if you don't do it properly. So that's really cool, though. The 10th Circuit has joined the chorus of others that have established the right to record police. Let me know what you think in the comments below. Thanks for watching. Special thanks to my top supporters in the month of July: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Gutbrodj, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.